We can call the final case from this morning's docket.
Morning, Your Honors.
Good morning from Johnson County, case number 127688, Todd Schreiner Excavating Incorporated Appellant versus Smith and Loveless Incorporated Appellee. Would the parties please state their appearances?
Terry Isles on behalf of the appellant, Todd Schreiner Excavating.
Dan Sanders, Your Honors, on behalf of the defendant and the appellee, Smith and Loveless Company.
Thank you very much. And would the appellant like any time for rebuttal?
3 minutes, Your Honor.
3 minutes are granted. With that, we may begin.
Thank you, Your Honor.
Yes.
May it please the court. This case is about the Fairness in Construction Defect Act and whether or not the district court erred when the judge determined that it was not applicable here. It's obviously a construction case. The contractor was Smith and Loveless, and my client was Todd Schreiner Excavating. It involved two different contracts. Essentially, they were pretty much identical. The first one was a three-tanker project involving 229. It was down in Port Comfort, Texas. It was executed in January of 2019. By the terms of the contract, it was supposed to be completed within 12 to 14 weeks. It wasn't. 9 months later, only 2 phases had been completed. While Todd Schreiner was at the project site, there was a second contract. It was for the installation of a separate wastewater tank at that site. It was referred to as the dirty tanker project because it had essentially sat for so long. There was so much work that needed to be done to clean it up and get it ready. Finally, we have a 3-day trial to the bench. The judge ruled in Todd's favor, Schreiner Excavating's favor. There were damages awarded. It took about a year before we could even get to the final journal entry of judgment. And in that journal entry, the judge ultimately determined the act was not applicable. So that's why we're here today, is to talk about the application of the Fairness in Private Construction Act, whether the amounts that we requested are, undisputed. And then we also need to look at the lien waiver. Was it a full and final release, violation of public policy, and some other issues? We believe the district court erred when she determined that the act was not applicable. If you look at the first particular case, which is the contract, which was the dirty tanker, it was $29,000. That's what was requested, and that's what was awarded. The dispute on that is that they didn't sign the lien waiver. That's why we weren't going to pay the money. The other one, there were several different requests for money. It was broken down in several different pay requests. And if you look at the journal entry of judgment, the district court broke it down as change order 478, which was for $7,100. That's one of them we're requesting. The demolition work, which was phase 2 of the project, which was the $62,782.50. That's another one that we're requesting. And then the retainage of the $10,463. We do recognize there was a dispute as to the interconnecting piping and the demobilization. But first of all, with respect to change order 478, they were approved. That work was done and that amount was owed. With respect to phase 2 for the $62,000, that work was done, that amount was billed, and that was never paid. They wanted to pay the money and proposed to pay the money, but they required the lien release with a full and final release of all claims. And then we have the last one of the retainage, which comes into play because the contract was essentially terminated at the end of phase 2. And keep in mind, my client was responsible for 4 of the 5 phases. First 2 phases were going to be done on site. He was going to demobilize, come back to Topeka, Kansas, wait until the concrete work was done, and then remobilize and do the other 2 phases. It's when he demobilized, the company did, and was here, that they had a falling out. They wanted additional terms. My client didn't. That's when the dispute pretty much arose.
Counsel, how do we figure out what it means to have an undisputed, or whether the amount was in dispute? Because The statute, the act doesn't define that. And so is it a line item dispute? Do we go piece by piece and say, well, this change order, there was no dispute about this change order? Or do we look at the fact that, for example, you requested significantly more damages than you were awarded?
I did, but I think you also have to look at it, first of all, is it wasn't a lump sum that we were asking for the total of this one project. It was broken down per invoice of what we believed was owed and when we was owed. Keep in mind, this is a 12 to 14 week project, and it's a fast pace when it's going to happen. It's not even a net 30 days after payment. It's net 15 days upon date of invoice. So where is it? How is it difficult to understand that disputed? I completely understand that, because we do have a definition of it in the other act dealing with public contracts, but we don't have it here in this particular act. But what I think you have to look for is you go back to the common law principles associated with contract, in that they are based upon good faith and fair dealing. And there must be a good faith argument as to why you're withholding that money and make a determination that it's not disputed. Here, the work was done. All right. Now that would be a dispute in a good faith effort that says that work was never done. And then the party had some kind of an argument, but there was no dispute as to work here. It was done. It was done in a workmanlike manner. It was accepted, and there was never a dispute on that.
But there was a dispute as to what you were owed.
There wasn't a dispute as to the $62,000. There wasn't a dispute, which is the phase 2. There wasn't a dispute on the contract, so that change order for $4,700 or $1,700. And there wasn't a dispute as to the retainage, which is what we're asking. What they argued was the dispute is the counterclaim, because they had to hire another subcontractor to come in and finish it. But if you look at the exhibit, which is, I believe, exhibit number, it's volume 13, and it's page, it lists what the disputes were. It's page 196 in volume 13. And every one of those items that were a problem were directly related to Smith and Loveless and the subcontractor they hired, not my client. And then if you also look at the remaining balance to be paid on my client's contract, that amount would have paid that other subcontractor. So there was no dispute about what should have been paid to my client.
Am I correct that part of the dispute was a set-off claim?
Yes.
That we're not disputing the amount, but we're disputing the right to payment.
Well, it's really
because we're owed a set-off and because we're owed a lien release.
Correct. Those twofold things, the lien release and the set-off.
Now on the lien release, I need to get in the weeds just a little bit. I need to clarify on page 36 of your brief in footnote 7, it seems to imply that you're claiming Smith and Loveless required you to sign a lien release that had different language than what was in the language of the forms that were attached to the contract. Is that correct?
No, that's not correct. And I think if I did state that in my brief, I misspoke, and I apologize for that.
So we're talking about the same forms that you agreed to at the beginning that were attached to the contract. Those are the form lien release you were asked to sign.
That's the form lien.
You just weren't asked to sign it until the end.
That's correct.
Some later.
Well, I think that's one of the issues too, because on one particular project, which was the 3-tanker, there were 5 payments, and my client was never asked to sign a lien release on any of those payments.
The contract didn't require a lien release for each payment. It gave Smith and Loveless the ability to request one. Is that correct?
That's my understanding. And I think that's our next issue, is whether this violates public policy and that it's a full and final release of claims and not limited to the payment itself.
Did you make that argument to the district court anywhere before your post-trial brief?
No, I did not. It was not. And I'll admit it was not raised in the pretrial order. And I think I raised that issue, and brought it to the court's attention. Where do I cut off? How do you raise a defense to a defense? I can understand them saying, well, that was never raised before in the pretrial order, but you got to understand, we have a trial in September of 2023. I raised that argument in a post-trial brief that their defense is not applicable because of that. It goes 1 year goes by and they don't even bring it up, nor do they object ever until we get to the briefing on the Court of Appeals.
They raised in the pretrial order that there were some problems with your claim under the statute.
but not my defense to their defense about public policy issues.
If you don't raise that argument in the pretrial order, how do you expect them to respond to it? I mean, you know that they're claiming a defense under the statute. Isn't it your obligation in the pretrial order to raise this argument to say, guess what? Under that statute, as part of your defense, we're also claiming you're not required, or we're not required to sign those lien releases
Well, here,
that you're basing your whole defense on.
I understand that, but I think it's twofold. One, I can't waive, and that's under 1801, I believe. You can't waive requirements under the act. Oh, excuse me.
Isn't that a different question? I mean, you can't waive it under the act, but you could still waive it and by not raising it to
Even
the
if my
court and giving
client-
the court an opportunity, or the other side, an opportunity to put on evidence or address it.
Well, I think they had the opportunity for a year to address it if they wanted to raise an objection to whether I raised a defense to a defense or not. You know, we do know the smoking gun doesn't come out in these civil trials and everything should be disclosed. I do understand the responsibilities, but where do we cut it off? Do I raise a defense to a defense?
Can we cut off in the
because I-
pretrial order? Isn't that the
Yes.
point of the pretrial order?
For affirmative claims and defenses to your claims? Yes, I
In
completely
responses
agree.
to them. I mean, as the plaintiff, you're also obligated to put in why you think those affirmative defenses don't apply in the pretrial order.
I don't know if I would necessarily agree with that. I think we could probably agree that we disagree, but how long are we going to make this pretrial order and how long is it going to be? But it's still a defense to a defense. My client was raising the argument and affirmative claim that the application of the act did apply, and they're saying it did not. I guess the question is, do I have an obligation then to assert why it doesn't apply and how many different places? But again, you know, the point is that went for a year and it was never raised or objected to until the briefing in this particular case. And so if we look at it from that perspective, they didn't preserve their objection on my particular defense to their defense. But regardless, I think the district court should have looked at whether this particular lien release violated public policy when it was a full and final release of all claims. But I also think you got to look at the other two issues in the case. And one is the condition preceding a mandatory obligation under the contract? And we believe, based upon the authority and the language, the plain language of the contract, that it's not mandatory. It's a discretionary requirement, and it's only became mandatory when they wanted it to their advantage.
Wasn't it up to Smith and Loveless's discretion to require it?
I agree with that, but to determine whether or not under the contract required a condition preceding for the lien release, you have to look at the plain language of the contract. You can't look at what they ultimately decide in the case. And the plain language of the contract said it's a discretionary may, if they require it. That kind of language is not a requirement to have a condition preceding. And obviously I cited the Sloan case out of Texas, and that goes into great detail when it explains that more than Kansas has. I think the other issue we brought up was the estoppel claim, is that you've never required it on the 3 tanker project under 5 payments, and then you never required it under 1 payment.
How were you prejudiced? Because normally we look at estoppel, I mean, the concept of estoppel looks at some conduct on the other party's part, and you acted in response to that conduct, and now you're prejudiced. So how are you prejudiced when the contract gives them the ability to require the lien waiver? What did you do differently in your expectation, and how did your client act differently?
Well, you know, I think that's a good question, obviously. But I think what it is my client wasn't going to sign it and release all other claims that they had, which was the problem. And that's what they wanted to happen. So that in turn, they didn't pay my clients money and went almost 5 years till September of 2024 before they made the offer to pay it. So, you know, it is a prejudice, but 5 years went by without my client receiving a dime for these final payments that he believed that he was entitled to. Unless you got some other questions, I'd like to reserve my 3 minutes if we could. Thank you.
Very much. And you still have your 3 minutes for rebuttal. Counsel?
Good morning, and again, I'm Dan Sanders from the Smith and Loveless Company. I'm going to begin and address some of his comments on lien waivers. Number one, I disagree with Mr. Isles. If you look clearly at Exhibit 4, which is on the record on appeal, you look at paragraph 8A, 9 and 19, lien waivers are mandatory. There is no doubt about it. I could read this verbatim, but you have it on the record. They're not discretionary, they're mandatory. If Smith and Loveless requested. On the dirty tanker job, that was a second contract for $76,000. Lien waivers were obtained from Mr. Schreiner and his company, Todd Schreiner. There was no objection by Todd Schreiner, president of the company. We signed those lien waivers to get paid. As to the public policy, no, I want to strike that a second. Lien waivers, if you read the briefs, I know you have, became critical on this job in November. Mr. Schreiner and his company filed 3 separate lien notices with the customer claiming damages or payment requests of $186,000 on the 3 tanker job and requested $30,000 in connection with the dirty tanker job, far more than he was entitled to under the contract. So at that particular time in November, it was critical for Smith and Loveless to obtain lien waivers. As to the public policy, that they've avoided public policy, that is a completely red herring argument. As the court correctly just noted, or the panel has noted, that was not preserved. It was not in the pretrial order. It was not argued at trial. The only argument,
Counsel, I'm going to ask you to direct your
Sure.
arguments to the court.
Okay. The only argument Mr. Isles made during the trial as to the lien waiver defense that he has was that, well, shoot, you didn't ask for it on the 3 tanker job before November. That was the only and sole argument made by Mr. Isles during trial. And in fact, there was a letter that came in as evidence as to that Mr. Isles wrote in December of 2019, where he said, we are happy, we are gladly will sign those lien waivers if you meet our demands, more money and amend the contract on the 3 tanker job to increase the values of the work being performed. Mr. Isles certainly did not have a problem with those lien waivers. So we consider it a completely red herring argument. This case was filed in January of 2020 and went to trial in September of 22. And as you probably have noted, there was extensive post-trial briefing on the attorney fee issue. That is the sole and only issue on appeal in this case. We submit that the district court, Judge Mason, was right. She was correct in holding and finding that the act, the Fairness and Private Construction Act, did not apply because the amount was in dispute, number one, and number two, the plaintiff, Schreiner, failed to submit lien waivers, which were a condition preceding to payment under the contracts.
Did the request for lien waivers apply to each and every line item payment that was being requested by Schreiner?
Well, he never really submitted. He just, basically, we just paid him when he made.
My question, for example, for each and every, I mean, they have some line items that are not disputed in the sense that they asked for they were awarded the same amount on certain discrete items.
Right.
That they had requested in their petition. And for each of those items, are you claiming I didn't pay each of those line items because of the lien waiver?
Those line items that you find in the petition and that they claimed at trial, and I'll use the example, the 3 tanker job, I think it came up to what? About $186,000. Those are non-contract damages. Nowhere in that contract are you going to find numbers that correspond to the numbers they asked for at trial. As we argued in our brief, those are quantum merit type damages. They have nothing, they're not tied to the contract. If you look at the
No, but my question is for the amounts that they asked for in their petition, where they were awarded the exact same amount for those discrete line items.
Yes.
Do you have a defense that, or are you claiming one of the reasons you didn't make those payments is because there wasn't a lien waiver?
Well, yes, I mean, overall, yes, that's true.
Would my question is, does that apply to each and every discrete line item that was requested in the
agree.
petition?
Because that's really post-job that those numbers came up with. They were in the lien notices, I believe, to some extent. But really what the numbers being circulated in November when we requested the lien waivers was, one, you just completed the demolition. Schreiner did. The contract says once you complete the demolition work, you're entitled to roughly $62,000. Even without an invoice being actually presented to Smith & Loveless, said, here, we got you a check for $62,000 shortly after you completed the demolition work. All you have to do is sign a partial lien waiver, the same one. There was no line item request or anything like that at that point. The only amount that he was looking for in November, that's when everything went south, of 19, was $62,000. So we asked for a lien waiver for that, which we were entitled to, especially in light of the fact that he had inserted these lien notices to the customer.
What about change order 478, the $7,100? Is part of your defense that you didn't pay that change order because you required a lien waiver for that payment as well?
Well, here's another problem we got with Schreiner. If you look at paragraph 11 of the contract, change orders have to be, the work in a change order has to be approved in advance before you do the work.
No, I understand that. I mean, I understand you may have other defenses, but I'm asking if
Never did.
is one of your defenses, I didn't pay change order 478 in the amount of 7,100 because I required a lien waiver and they wouldn't sign it.
And that's in connection with the 3 tanker, Justice.
Mm-hmm.
That request was never made until after the fact. The only
Yes or
he was
no?
asking for
Yes
was
or no? Is
$62,000.
one of the reasons you didn't pay change order 478 because you required a lien waiver
I would,
in order to make that payment?
and that,
Yes or no?
yes, because you didn't have a lien waiver. We're gonna make any payments at that point without a lien waiver as required under the contract.
What about the dirty tanker project, the $29,000 payment that was awarded at trial?
Right.
Was your defense to that payment as well? We required a lien waiver for that amount?
Yes,
Was that requested before the lien waivers were being required?
he was requesting, the purpose, if you recollect from my brief, there was a meeting on November 7th of 2019 to try to work out the extra money Schreiner was claiming on the dirty tanker job.
Right. I'm just trying to get the timeline straight.
So in November, the agreement was, I can get you another 14. We already been paid 67. The only thing left was retainage of about 7. We agreed at the November 7th meeting, we'll pay you the other 14 if the president approves it, which he did. We're not paying you another 21. And Schreiner agreed to it. And that led to, hey, we got a check for 21,000 for you on November 14th. All you got to do is sign a final lien waiver. So we never agreed to the 29,000. Again, these are quantum merit type damages. And under the law, and like the Midwest asphalt case, if you're seeking quantum merit damages, you're not entitled to relief under the act. You're not entitled to attorney fees, and you're not entitled to 18% prejudgment interest. The fact is, and I think you brought it up initially with him, is the act, and Mr. Alves is correct, does not define what an undisputed amount means. You can look at the sister act under private construction. And I agree with Mr. Isles. I think it's a good faith standard. And I can tell you at all times relevant, my client has acted in good faith with Schreiner Construction. We tried to get him paid in November for the demolition work. He had no problem with that, just had to sign a lien waiver because he had been filing lien notices. We tried to get him paid after he completed the dirty tanker job. We agreed to 22. We got a check cut for him and he wouldn't sign the lien waiver. Instead, he went out and filed a third lien notice instead, which we still don't understand why he did it. At all times relevant, we tried to get this guy paid. We're now 5 years down the road. And in fact, after the judge issued her judgment, I believe in February of 23, we tendered a check for the full amount of the judgment, no strings attached. Just, we sent it to Mr. Isles and said, cash it. You can go ahead with your appeal. That's fine. That's your right. We want to cut off post-judgment interest, which the law provides if you tender a check that will cut off post-judgment interest. But we sent that with no strings attached. So I think that's just further evidence that at all times relevant, My client, the Smith and Loveless Company, has acted in completely good faith with Schreiner Construction. Why he did not take the $62,000 back in November, which was the only amount he was owed under the contract at that time, I don't know why. And number two, he never came back and finished the job. And if you look at the case law in Kansas, by not completing the contract, that disqualifies him from obtaining attorney fees and prejudgment interest at 18% under the act. So there's really three reasons why the judge determined that the act didn't apply. One, we had a good faith dispute as to the amount that was owed Schreiner. Two, he didn't sign lien waivers, which was required. And number three, he never completed the three tanker job. If that's not a good faith dispute, I don't know what is. And therefore, we ask that the judgment be affirmed. In this case, after 5 years, needs to be put to rest. And we're still prepared to pay that $134,000 once this judgment's affirmed. This is not a case where we got a contractor that knows he owes the money and just comes up with a bunch of silly excuses why he's not going to pay. This is just the opposite. We've been looking to pay this man for 5 years. This case needs to be put to an end. We need to get Mr. Schreiner paid. Thank you.
Thank you very much. Counsel, you have 3 minutes.
Thank you, Your Honor. This is actually one of the cases that the act is designed to protect, and that is that payment should be made in accordance with the contract of the parties. The lien release was a full and final release of all claims. That's why he didn't sign the lien releases when it came right down to it. There were so many other things that were owed, and the concern was that he was going to release all those claims. Yes, the money was tendered after the judgment was entered. The question does come up, does it make the appeal moot or not? And so obviously, I think you understand what the requirement, but we thought that maybe we should just send the money back right now if we're going to continue with the appeal. No quantum merit here. The judge dismissed the quantum merit claim, made a determination that all damages were awarded under the contract. There is a change order provision. All the change orders that we are requesting here were approved. They tried to leverage a settlement on the dirty tanker project for him to accept $21,000, and they wouldn't pay him the $29,000 when they had already been paid by the owner. They had that money in their pocket, and yet they only wanted to pay him $21,000 with a full and final release that he can't come back after that other $8,000.
Counsel, isn't that the kind of dispute, though, that prevents the application of the act?
Prevents the application? I don't think so, Your Honor. That's trying to use a lien waiver to your advantage where the act says that's against public policy. But even if you accept the argument that it's not raised in the pretrial order, you have to look at the actual contract itself to determine whether or not it's mandatory. Not Mr. Sanders' argument, not what he thinks that his client wanted. You have to look at the plain language and only the plain language of that contract to determine whether or not it was mandatory. And there's too much discretionary language in that contract to make it mandatory. And that Texas case, that Sloan case, was right on point. I'm probably losing my time. With that, we would respectfully request that the district court be overturned, remanded back for determination as to the application of the Fairness in Private Construction Contract Act. If you have any questions, I'd be willing to answer. Otherwise, I'm finished. Ladies, have a good day.
Thank you very
Thank you.
much.
Thank you.
We'll take the matter under advisement.